Well, Mr. De La Mayor, you or I suspect, in particular Mr. Mater, have been very busy.
Yes, we've done what's asked. It's not in dispute, and I propose to say no more or less.
Well, that's absolutely right. We're very grateful to you. We don't propose to ask you to say anything else, but we are grateful to you and to Mr. Mater for your industry and, in my case, enlightenment. Now, Ms. Ward.
Hello, it's my lady. We left things yesterday afternoon on what I identified as the second issue.
Yeah.
That of whether prioritisation is necessary.
Yes.
Before I come back to that, I just want I have one point to go back on the first
Yes.
point about whether Article 21 is in play at all. And this isn't a further submission, actually, but an apology on my part for an error in my first supplementary skeleton argument. And I don't want to complicate matters or take time up.
But there's a but coming.
Could you revoke to? In paragraph 9 of that supplementary skeleton.
Hang on, whereabouts? What's it in the Bible?
17.
Thank you. 17.
17.
Oh, yes. Yep.
Oh, the one on the I made a point by reference to Article 27 of the Implementing Regulation.
So paragraph 9?
Paragraph 9 on page 139. I made a point by reference to Article 27 of the Implementing Regulation and the reference there to staying in another country. And it occurred to me yesterday when Mr. De La Mayor asked for the Court's attention to be drawn to the definitions of residence and stay in Article 2 of the main regulation that I hadn't ever corrected the error in that paragraph, but I had conflated those two concepts. And I accept that. I don't think time needs to be spent on it. I just asked the Court to draw a line through that paragraph by the first sentence.
The whole paragraph can go, can it?
The first sentence I stand by, and there's no reason why Article 20 shouldn't.
So from it onwards.
But from it onwards.
Struck out.
I withdraw that. I apologise for my mistake. And Mr. De La Mayor very charitably suspicious on the floor. He did draw your attention to the provisions that make it clear, so I want to correct that. But I do, of course, maintain, for all the reasons I gave yesterday, that Article 21 can operate, does operate, so as to give the appellant in this case a prerogative right in these circumstances. I think that, subject to Mr. De La Mayor's nuance about Article 21, shouldn't be read that way if it's a prioritisation provision. That much is effectively common ground. And it certainly was the uncontested understanding of the Conciliation Board, whose opinion the Administrative Commission adopted. So, in terms then of a roadmap for the rest of my submissions, I propose to finish off on point 2, firstly by looking at that Conciliation Board opinion, and then returning to the issue of overlapping, which is where we left things yesterday, and then on the what Mr. De La Mayor I know characterises as an ambitious assumption that the Court is with me at that stage to address my third point, how to prioritise in this case if that is required. So before I ask the Court to turn up the Conciliation Board opinion, it may just be worth noting the role of the Administrative Commission in all of this and the purpose of that body. And Mr. De La Mayor, those instructing him, helpfully produced yesterday a full copy of the regulation, which serendipitously includes the relevant articles which hadn't been put into the bundle. So it's Article 71 and following, beginning on page 40. 40, yes. So Article 71 provides that the Administrative Commission for the Coordination of Social Security Systems shall be made up of a government representative from each of the member states, assisted where necessary by expert advisors, and with a representative of the European Commission to attend the meetings of the Administrative Commission in an advisory capacity. And its tasks include, by Article 72, dealing with all administrative questions and questions of interpretation arising from the provisions of this regulation.
So all 28 member states send somebody.
Yes.
And this
27 now.
Yeah, yes, okay. I'm for the moment Okay. And then, and these will be, they won't be lawyers. They'll be, what sort of person?
Government representatives.
Civil servants from the Department of DWP in our case, would it be?
Most likely,
Would have been.
Yes. But with expert advisors where necessary.
So what sort of people will be the expert advisors?
Depends on what's necessary, I think. But it will have access to the legal advice of the Commission.
Legal advice.
But including.
Okay. Right.
And the point I make is that it is the body set up for that purpose, with that representation and access to those sources of assistance.
So its tasks include dealing with questions of interpretation.
Yes. And specifically, in this case, the task assigned to it under Article 6 of the implementing regulation.
Do we have that?
We do have that. That's tab 12 of the authorities bundle. 143.
Before we get there, when it says deal with, that's a word that could mean a lot of things. But if we look at 71(2) second paragraph, that gives us an idea of what dealing with means, because it does say decisions on questions of interpretation to be given the necessary publicity. It looks as if it can decide, doesn't have to, I suppose, but it can decide.
Yes.
And it can say it means X, it doesn't mean Y.
It can do.
Yeah.
Well, that's what I want to drill down to, actually.
That's what I thought you were.
Yes. So, go on then. You're taking us to the...
In this case, under the implementing regulation, and that's at tab 12 of the Bundle of Authorities, Article 6 on page 143.
Article 6.
It's Article 6, that's it appears at the top of the page. There's a lot of 143 of the Authorities Bundle.
Oh, yes. Sorry. Yes.
So this is the difference of views provision. And Article 6.2 is a provision for where there's a difference of views between the institutions or authorities of two or more member states and which institution should provide the benefits. The inflation payment provision basis. And then paragraph 3, where no agreement is reached between the institutions or authorities concerned, the matter may be brought before the Administrative Commission by the competent authorities. And the final sentence there, the Administrative Commission shall seek to reconcile the points of view within 6 months of the date on which the matter was brought before it. And my lords and my lady, in this case, whatever else it has done, the Administrative Commission has sought to reconcile those points of view.
So what happens after? Is there an appeal process?
No, that's it.
This is a decision by administrative diktat, not by a judicial process.
It seeks to reconcile the points of view under this provision, and the status of that, for our purposes, is governed by the withdrawal agreement. And I promise this is the only instance of which I'm going to ask you to look at.
You're not going to ask us to interpret.
Not at all. I think it's relatively straightforward. So that's tab 14 of the Authorities Bundle. And on page 173, you have Article 21 of the Withdrawal Agreement. And that's the article that firstly provides that the regulation 883/2004 and the implementing regulation shall apply. And then the second paragraph under Clause 1 of Article 31. The Union and the United Kingdom shall take due account of decisions and recommendations of the Administrative Commission.
What does that mean?
Well, in my submission, very similar to have regard to. Due account, there may be an issue as to what is due account, but this court is required to consider what it has said.
So within the union, the decisions of the Administrative Commission are binding. Are binding on member states?
They are, I think it will depend on the particular function that the Administrative Commission is carrying out. So,
A lot of knowing smiles going on, Frank. As if is there some problem with this?
I don't think it's a problem, my lord. It's a process for resolving issues.
Yes.
And insofar as the Administrative Commission determines, as between member states, that one rather than the other is competent in a particular case or is responsible for the payment of benefits, it follows that that's how the member states will interpret the regulation. But
is it binding? My question is it binding on member states, the decisions of the Commission?
I'm being assisted from behind. It's not an official decision.
It is an official
No,
decision. It is. It must be. That's what section Article 21(2) says. Official doesn't add anything. It's clearly a decision. It's capable of being a decision, and it comes from somebody who's pretty official. The question is, is it binding?
I think official decision being used in the sense of formally binding.
The question is it binding on the authorities of the United Kingdom,
Well,
and even more so on the judicial authorities?
So my question was, what within the Union, first of all, was it binding on member states? And then the law adds, what's the position now when you look at due account? I mean, to some extent, this is irrelevant for where we are. Well, I think it's irrelevant, but it's interesting to know.
My lords, my understanding certainly is that there's no provision that makes it formally binding. It is important and authoritative, and member states will generally abide by it.
Is there a process of enforcement through the CJEU?
For example, if the
CJEU may not agree.
So Article 6(4) of the implementing regulation, for example, as a consequence of what happens where it is established if the legislation is not that.
You're back at tab 13, are you?
Well,
Tab 12, sorry. 6(4).
It does seem to me to be a somewhat flawed process because the decision of the Administrative Commission is by a qualified majority. So if you get 21 member states who think that the directive means X and the remaining member states think it means Y, then it's a pretty foregone conclusion which way the Administrative Commission is going to go.
It's not a decision for the purposes of that article of the treaty. I forget, is it 267, not 267, the one that says there'll be regulations and so on, and decisions are binding on members. It's not a decision of that state.
Right. I think the answer to where my Lord Justice Baker's point goes is that if one of the 5 member states, in my lady's example, continued to implement the regulation in the way that they believed was correct, ultimately that would need to go to the CJEU.
Yeah, I would expect that to be the case. Although I think Mr. Delano shook his head a minute ago. Anyway, we probably don't need to go down that track.
So can we use the position under the withdrawal agreement to decide on the status or relevance or helpfulness of the Administrative Commission decision in relation to matters that occurred before the withdrawal treaty?
Yes, I don't see why that. This is.
We're post-withdrawal and therefore the withdrawal agreement must govern us.
But this is the status of a decision about the position pre-withdrawal. But it doesn't matter, you say.
I say this court has to have due regard to it.
How can the withdrawal agreement help us about the interpretation of the regulation before the agreement? I mean, that may be a naive question, forgive me, Ms. Ward. I'm sure it's my fault for stating it in sort of different language. But forgive me.
Well, that's a very good point. We are in a post-withdrawal agreement world.
We are.
We cannot, because of the withdrawal agreement, refer this question to the CJEU. Not because of, but under the withdrawal agreement. So, insofar as any provision of EU law remains applicable, and I think that is the correct word in relation to OK 2004, slightly different issue with residence rights, but Reserves 883/2004 therefore remains applicable. Insofar as any decision of the Administrative Commission continues to have force or authority in this jurisdiction, it must be through the withdrawal agreement. Otherwise, any requirements under the treaty would simply fall away.
Yes.
We decided whether the decision to suspend in 2015 was lawful,
Yes.
and that would have the consequence from 2015, 16, 17, 18, 19 for 5 years before withdrawal was finally brought about. When did we withdraw? Was it the end of January 2020?
It's 11 o'clock on the 31st of December 2020.
Was the end of the implementation period. So there was, it was this 11 o'clock on the 31st of January 2020 was exit day.
Yeah, and
And then
implementation
there
is
was,
different.
but then
yeah.
with the implementation period, EU law remained applicable.
So for the period,
Until then.
certainly for at least 5
Until
years,
January 2020.
for at least 5 years, the position is just by reference to EU law when it wasn't when we were a member state.
Yes.
And then there's an interesting question as to what happens to it after. But it'll carry on, I imagine. I mean, how old is the child? Born in 2009?
09.
13, no.
15
Got
this
3
year.
years
16
sticking
this
into
year.
the withdrawal agreement. Right.
She's born in 2009.
16 this year.
14 this year.
14.
9. 14.
My Lord, if it assists, the reason we asked for Section 16 of the Interpretation Act to be added to the bundle is that our understanding is that in the period before the coming into force of the withdrawal agreement, it's Section 16 that covers. Even though we have left, the law is still treated as it was, and the binding status or not of an opinion like this is governed by the EU law that was in force at the time before the withdrawal agreement. And that much is plain from Article 31, first paragraph.
Of the withdrawal agreement.
Because to get into the withdrawal agreement, you first of all have to show that you're a person covered under Article 30, and then 31.1 says that it shall apply to the persons covered by this title. And that means that the binding status or not, or the have due regard to obligation in 31.2 is directed at those cases that are being litigated under the withdrawal agreement. My London friend, with respect, can't have it both ways. We can't be in a situation where no reference is possible because the facts precede the withdrawal agreement and simultaneously point to the withdrawal agreement for these purposes. If I could just point out one other thing, this body is of a form that is very common in EU law. There are coordination bodies like it.
Over everything.
For instance, in telecoms, there's a body called BEREC. In data protection, there's a coordinating body for the data protection body.
Yeah.
And they're advisory. They're not binding.
Can I just rewind to see where we are? For the period 2015, when it was withdrawn, I forget the precise date, to the period 2020, in any event, we were a member of the European Union, and for each of those years, for each month that you wanted the benefit, EU law, when we were a member state, applied anyway. And I forget the date of the Administrative Commission decision, but we're looking at pre-European Union withdrawal, and I'm not sure we need to get into the withdrawal agreement at all, is my provisional view. Now, if somebody says to me, yes, but we're even ahead of you there, things changed at 1 minute past 11 o'clock on the 31st of December, then we'd have to look at it. But I was innocently assuming that it was the position in 2015.
With respect, there are entirely separate provisions in the withdrawal agreement that deal with pre-existing administrative procedures. So things that started before we left that carried on being dealt with after we left. And I suspect that these types of measures would fall into those provisions rather than into the withdrawal agreement provisions themselves.
Well,
at the end of the day,
haven't been taken to any.
no. At the end of the day, the bottom line question is this: is the decision binding on the individual? That's the question, and it's very difficult to see how a decision like this could be binding on an individual in circumstances where they don't even have locus before the relevant body.
Well, ultimately, I have not suggested it's binding. At
No.
no stage, I've always said
You said,
due regard.
well, you said the reverse. I've written down no provision making it binding, is what you say.
I've never suggested it's binding.
But in terms of the ambit of this appeal, I had assumed, I think we'd all assumed, we weren't going to have to get into interpretation of the withdrawal agreement and that sort of issue. We were really looking at a decision taken significantly several years before we withdrew, before the referendum. And that's the issue. It may well be that there are subsidiary issues that would arise in this and other cases under withdrawal agreement, but that's not formed part of the issue in the courts below. And for my part, I would be reluctant to get stuck in the weeds of it now. However interesting it may be. The more interesting it is, the more careful we need to be.
Well, firstly, I'm not inviting you to get stuck into the weeds of anything. I thought, and I apologise because I was clearly mistaken, this was a relatively uncontroversial point. And the reason I thought, or part of the reason I thought that, was because it was a submission that was made at the time when this matter was stayed by Lord Justice Popplewell back in 2021, that the matter was going to be referred to the Administrative Commission.
Yes.
This process was going to be pursued, and therefore it ought to be stayed to enable this court to take due regard of the decision of the Administrative Commission.
Right.
And that had never been said previously, so I confess that I hadn't then undertaken the exercise of working through the points that Mr. Delamere now raises. I don't understand it to make any significant difference to the task that faces this court, which is simply to reach its conclusion on the interpretation of the regulation, deriving such assistance as it can from the decision of the Administrative Commission.
Yes.
Can I stop you there? I've just looked at it and it's headed opinion. So none of this may be relevant. It's an opinion, and because of its extreme eminence, we would look at it very carefully anyway, I would imagine.
My Lord, it's an opinion of the Conciliation Board, which was then adopted.
Oh, it's adopted by decision, is it? Oh,
It
right.
is.
Yes.
Well, I haven't seen the decision, Doctor. What's the date of the decision then?
Is that in the bundle?
It's post IP completion date.
It would be,
Oh,
wouldn't
it's
it?
all post-IP completion date because the matter wasn't referred to the Administrative Commission at all until post-IP completion date. So all of this took place
After.
afterwards.
Right, okay.
Okay. All right. Well, should we get back onto the track? Back on onto the main road, having done that
Done it.
little diversion. Right.
Well, as I say, on NQ, we're all agreed that the decision of the Administrative Commission, which was to adopt that opinion, does not resolve the issue.
No.
It may well seek to reconcile the competing views, as Article 6 directed the Administrative Commission to, but it doesn't provide an answer. Even if it did, we also agreed that answer wouldn't be binding on this court, it would be taken into account, had regard to, and what I say about the Conciliation Board opinion, firstly, is that it's clear from that opinion that I'm right on point 1, that Article 21 is in play, or at least that the parties to that procedure and the Conciliation Board itself considers that to be the case, and that it shows that those parties and that board agree that there is a need to prioritise, but that there's no express provision in the regulation itself for how to do that. Now, the Conciliation Board opinion is in the core bundle at tab 19.
We had the decision as well. I only found the opinion. That's why I hadn't realised there was something called a decision as well.
Well, that doesn't, I'm afraid, seem to find its way into the core bundle. You can find
I think
it.
we ought to if that is the decision.
I agree. So we're going to the opinion.
The opinion, tab 19 of the bundle, beginning on page 146. And after setting out the basic provisions in play, the presentations by the delegations are set out from page 148 onwards. Now, in relation to the initial representations of the Belgian delegation, it set out that Belgium considered that there was a difficult issue as to which rights should be given priority. So Belgium accepted Article 21 was in play here, but finds it difficult in the case in point to determine whether priority should be given to the child's individual right to a cash sickness benefit on the basis of residence in the United Kingdom, or to the derived right to a possible cash sickness benefit under the legislation of the father's member state of clear rules of priority, doesn't suggest that there's no need to conduct that exercise. Pointed out in the second paragraph under that heading that there was a priority rule in Article 19 formal regulation that hasn't been repeated, and then in the final paragraph on that page in the bullet points focused on, highlighted the impact
On the facts of the case.
on the facts of this individual case.
Yeah.
If it was the derivative right under Belgian legislation that you take priority over the right based on residence in the UK, and in view of those facts, top of page 149, took the view that Article 21 shouldn't automatically exclude the grant of cash sickness benefit by member state of residence to a family member who works and is insured in another country. Now, of course, my case isn't with Article 21 will in every case exclude the grant of cash sickness benefit where there's one parent working and insured in another country, because of course if there was economic activity in this country as well, then different questions of prioritisation would arise.
Why?
Why?
Why? I mean, what you get in that situation is the point that my Lord Justice Lewis postulated of, let's say, the grandparents looking after the child, one mother working in France, and the father in Belgium. And so you've got two lots of derivative rights, and both of them are rights under Article 21, and nothing to say how you resolve priorities between those two.
Yes.
Well, doesn't that rather suggest that it would make more sense for the default position to arise where the rights of residence would trump everything else?
Well, maybe that's a question of how one prioritises, and I am going to come on to that. But hopefully, in the interest of getting through things in as swiftly as possible, I might park that when I come on to that section of my submission.
I was just querying why different questions are. Your submission was that different questions arise if you've got the two-parent situation, and I wasn't quite sure I understood that submission. It's my fault, I'm sure.
I'm very sure it's my fault. I will come on to that issue as to how one prioritises in different situations. But before we get there, the question has to be: does one? Is there a need to prioritise? And it is my fault for making that as an aside about what Belgium was saying, rather than focusing on.
Your point is there is a need for prioritisation because Article 11 envisages that there should be one governing state.
Yes.
Yeah.
And to buttress that, and to buttress the submissions I made yesterday, I point to the fact that no one before the Conciliation Board, and not the Conciliation Board itself, was suggesting that that was not the case. The UK submissions.
Yes, I've read the submissions. So UK submissions broadly follow what you're going to tell us.
Yes.
Whereas the Belgian submissions are rather different from how it's been put before us.
They're different, but on this issue, they don't take issue with the need to prioritise in both rights.
No, you're right, but the arguments put in support are very different.
The arguments put in support on the prioritisation issue are focused very firmly on the individual facts of the case.
Well, what do you mean in Belgium? Yes, you're right. The Belgian, the bullet points at the bottom of the page it was. And there's no focus on the language of 11 in the way that it has been before us. Sorry, she's right.
I will say that those are points that go to, because of course all the submissions are set out compendiously, we have both Belgian submissions on effectively whether prioritisation is needed, not really submissions on that point because that's simply understood, implied, it lends weight to my submission that that prioritisation exercise is necessary.
Right.
Belgium agreed as well that it was necessary, and that the conciliation board didn't, as I come on to show you, take issue with that proposition
Okay.
either.
This is still your second point.
So it's still on my second point.
Yes.
The conciliation board then goes on to set out the United Kingdom's position, which broadly in line with what was said in the Upper Tribunal and the submissions that
Yeah.
I've made to you. And then the conciliation board's analysis begins at the bottom of page 150 to be disposing of a point in relation to benefits in kind in the NHS, which we don't need to.
That's not
I hope
an
issues.
Good enough to worry about.
Don't have to worry about it. Disposed of. No one's seeking to resurrect it. And then on page 151, begins with the common ground, effectively that the interpretation of Article 21, that it's common ground, I think, between at least myself and Mr. Berry, that it can apply in this situation is correct. And then
Yes.
and then identifies the and at the bottom of page 151 identifies the questions as being whether Belgium is competent by priority, and if so, whether this precludes entitlement under domestic legislation. So again, the question of whether Belgium is competent by priority falls to be determined. And on that first issue, starting at top of page 152, the conciliation board starts by referring to the concept of single applicable legislation under Article 11, and then notes its common ground that the overall scheme prioritises life space and economic activity. I noticed it used the term residual wool for 11.3, which my lady may prefer to fall back. It's what's left if one isn't in any of the other categories. It goes on to note that the old Article 19.2 was not retained, but under that, if that provision had been retained or duplicated in the new regulation 883 of 2004, it would have been, the appellant would have been entitled to under UK law, but in its removal, and this is the bottom of page 153, leaves what it terms a legislative gap.
Yeah. Before we get there, do you accept that if we'd been under 19.2, I can't remember whether the others did accept it or not, but under 19.2, the position in this case would have been the child got it in England and had to get it in England and wouldn't even have had a fictitious a right to claim it in Belgium. That's the position.
Yes.
So we're looking for something that switches that position under the new regulations, where if she could claim it under United Kingdom law, on your case, it has now been switched and exclusively switched to the state of economic activity of one of the parents.
That's the consequence.
Yeah.
So, yes.
And what's striking to me about the opinion here is there isn't the same focus on the wording of
11.3e that we've had yesterday.
Yes.
I'm looking at the middle sentence in the middle paragraph on 152. Or well, the whole of that paragraph that begins, it is also common ground.
Well, that is, of course, against the context of having set out what is common ground earlier in the opinion when setting out the submissions of the parties.
Yeah. So the principle of that legislation of the state in which a person works takes priority found its expression in 11.3e, which is a residual rule providing for the application of the legislation of the place of residence only to persons to whom subparagraphs A to D don't apply.
But all that means is that for Amelia, she's only got E for any claim in her own right.
That's right. So this is, of course,
My Lord, there is discussion of 11.3 on page 155 in the penultimate paragraph.
Thank you. Okay.
That's the meaning of without prejudice.
well, sorry, I will come on to page 155. That is, of course, in the second section of the judgment, which is whether Article 21 precludes this language here.
Okay.
All right.
That's what I'll come on to what I say about that in a moment. In relation to the need to prioritise.
Yes.
The conciliation board is clear that that's something that needs to be done, that there is a gap left under the terms of the current legislation, and that could be resolved in, say, effectively one of two ways, and by ways I mean substance rather than method. There are a number of ways to propose as an interpretive decision, amendment to the legislation, reference to CJU. But in terms of where that might take you substantively, it effectively says, well, you could retain the position under the old 19.2, which wasn't done. If you look to do that, and that would have the advantage, particularly in this case, a case where there is no right to sickness benefit on the individual facts under the legislation of the country competent under Article 21 of ensuring there was some benefit. But equally, you could close the legislative gap by extending the more detailed priority rules contained in Article 32 by analogy.
Before we have the Administrative Commission, there appears, they say, there appears to be a gap. And then they say at the top of 154, the Administrative Commission could consider adopting an interpretive decision.
Yes.
By that, I thought they meant they could have adopted a decision as to what, on a proper interpretation, applying theological approaches and so on, was the right thing. And they seem not to have done that. And then I say to myself, why don't I grasp the nettle, Miss Ward? Why don't I do it? And why don't I say what appears to be a gap on a proper analysis of purpose, history, words, the 27 member states' languages, it actually means this and there isn't a gap, either because it's what you say or it's because of what
Yes.
they say. Somebody's got to do it.
Well, Lord, yes, that is the task before this court. And what
So
I'm
we
saying
can do
is,
that then.
accepting that there is a legislative gap. And
They
of
drag
course,
me into it.
Yes.
because my learned friends say there isn't,
Mm.
and that the regulation answers it for itself.
Mm.
My submission is that that legislative gap was rightly recognised by the conciliation board, and therefore does have to be resolved.
Yeah.
Yes. And
What
that
you
is-
say when they say gap, I underline the concept of gap is the idea that there should be a prioritisation route.
Yes.
It's inherent in
Yes.
it that there's a
There's a
prioritisation
need to
route.
prioritise these.
And they were very, very worried that it hadn't been spelled out expressly under the heading priority rule.
Yes.
And they then we'll get to your part 3 shortly. If we have to have one, is it the UK state of residence or is it Belgium state of fathers economic activity?
Yes.
Yeah.
Exactly that. So
Yeah.
I don't think I'll take that any further.
Mm.
The conciliation board recognised, emphasised the need to decide whether Belgium was primarily competent.
Yeah.
It then went on to look at, insofar as it reached a conclusion on that, it appears to have considered, at least hypothetically, that Belgium could be regarded as primarily competent.
Yeah.
Now, I don't accept that I've ever submitted that it decided that Belgium should be.
Yeah.
What it decided was that Belgium could be, that is effectively an available interpretation of the regulation. And it then went on to look at what the consequences of that would be on the basis that UK law gives a domestic right in those circumstances. Now, of course, what I say is that that's wrong, because what section 72(7)(b) says, that's at tab 2 of the bundle of authorities.
Mm-hmm. Yeah.
So on page
12.
on page 12 of the bundle of authorities, that a person to whom this regulation applies shall not be entitled to the care complaint Disability Living Allowance for a period unless during that period the United Kingdom is competent for the payment of sickness benefits and cash to the person for the purposes of Chapter 1 of Title 3. Notice it's Title 3, so Article 20, that includes Article 21. And there's no provision in Title 3 that renders the UK competent. So if Belgium, if that's on the hypothesis that Belgium is primarily competent, section 72(7)(b) excludes entitlement, and therefore I submit the second part of the Conciliation Board's opinion doesn't arise in these circumstances.
Hang on, competent for the purposes of Chapter 1 of Title 3. But the competence derives from parts of Chapter 2. You can't just say, oh, because there's not a specific provision in Chapter 3 that makes it competent, you ignore everything that goes before. Otherwise, if the UK was competent because it was the place of economic activity as a result of 11(1)(a), that wouldn't apply either. That's nonsense. Sorry.
Well, your submission is superficially attractive.
Just thinking out loud, Miss Ward, you've got three situations. If the only state, if in fact we were to find that 19.2 is impliedly carried forward into the new regulation, and the only state is the state of residence, that would be the United Kingdom, and that wouldn't actually be for the purpose of Chapter 1 say that it's dealing with sickness benefits. But it must be the case that whatever 72(b) says in its words, it must mean that if the United Kingdom is the only competent state, it's that. If the only competent state was Belgium, because there's an implied priority rule and it is Article 21, then you couldn't get it under 72(7)(b), because that's tying payment to competence. The interesting question is, what if it's both? If it could be a choice, either the United Kingdom or Belgium, as Mr. Berry says it is it a competent state, in which case it's all right, or, well, it must be a competent state if they're right on choice, if it means what they say.
Yes, I mean, if it means what they say, because the 72(7)(b) has to be compatible with EU law for these purposes.
Yeah.
So
you really only win if you show that it is actually Belgium and only Belgium.
Yes.
Yes.
And that's what I say.
Yeah.
That's what I say the Conciliation Board is looking at in terms of the regulation.
Mm.
In the context of having started its analysis by looking at the concept of single, the provision of Article 11A on.
So,
Having started its analysis by reference to the complete and uniform system of conflict rules, then the conclusion that Belgium is primarily competent because in order to determine for those if that's right, then there is no right under domestic legislation. Now, what I say the second part of the conciliation board opinion is doing is looking at, well, what would the position be if 727B wasn't there, and if
It can't be doing that. It can't be interpreting the domestic legislation. It's got no role in that.
so I don't. Well, that's absolutely right. I'm afraid I didn't word that. The conciliation board was not considering section 727B. It does appear to have been considering the matter on the basis that section 727, it doesn't mention section 727B, and it wasn't, as I understand it, directly drawn to its attention because it wasn't in play in the appeal.
Do we? So are we now focusing on
Page 155.
Well,
what we got there?
we're about to get there.
And
I imagine you're going to have to tackle, aren't you, the middle paragraph? And what you...
Yes. So, well, yes. So what the conciliation board then goes on to do is ask whether, on the assumption that in the present case Belgium is regarded as the competent member state, this is the top of page 155, the question still arises whether the competence of Belgium would preclude concurrent entitlements to cash sickness benefits under legislation of the United Kingdom based on residence. And that's the UK position based on Article 11.1. It's also the UK position that if Belgium is competent, it is not competent.
So, okay. So then, however paragraph on 155 starts with an assertion which seems to be contrary to your submission. And goes on with a number of other assertions which are contrary to your submissions. Doesn't it?
Well, it is, of course, possible in some circumstances, and this was an issue that was debated to some degree before the Upper Tribunal, for member states to provide for benefits in situations where they are not competent under the regulation. And that's what the UK government has sought to not do explicitly and to make clear as a matter of domestic law in section 727B.
But those earlier bits of the paragraph, I mean, it's all building up to the sentence that you've got to say is simply wrong, otherwise you're stuck. It's the sentence that says, likewise, it may occur that a person is entitled to individual benefits on his or her own right and to the same kind of benefits by virtue of being a family member. And you have to say, that's wrong. You've got to, really. And you've got to say, it's got the meaning without prejudice wrong in the way that we were discussing yesterday. The second half of paragraph 3 on that page, you've simply got to say is wrong.
Yes, and I do.
Good.
Right. Well,
Why don't you develop that argument and then I'll come back if I need to.
It's a relatively short submission that in the context of the regulation, one has to, having had to identify which state is competent by priority, then the question of whether another member state may, in certain circumstances, choose to not exclude the grant of basic benefits on the basis of residence may arise if the member state in question chooses to make that provision. And there are circumstances in which that is not, as a matter of EU law, permissible, and the Upper Tribunal in this case held in finding against which there hasn't actually been an appeal, that was the case here, that section 727B is not just a provision that the UK was entitled to enact.
I'm sorry, Ms Ward, it really is my fault that this is so difficult. I just don't understand this. It's simply wrong, isn't it, if you're right? I just don't understand. Stick to the facts of this case. We're only talking, and the whole opinion is about this case. It's whether a child who gets the benefit by virtue of residence in the UK or by virtue of family member in Belgium. That's what it's talking about. so I'm getting confused when we talk about other benefits. Am I right in thinking, first of all, that this paragraph is saying that this child isn't precluding from getting it in Britain, even if the assumption is that Belgium is a state of competence? That's what this paragraph is saying, isn't it?
Well, I'm not sure. It doesn't say that in explicit terms.
It's not talking about the individual child, but it surely, well, on one reading it would follow, as all is suggested. I mean, the sentence, let's look at the likewise sentence, because I think the Lord's right. That is the key sentence here. So I think all of it builds up to it. I think you'd have to challenge the building blocks of the first two sentences. But if we focus on the likewise sentence, likewise, it may occur that a person is entitled to individual benefits on his or her own right and to the same kinds of benefit derived from the social security scheme of another member of the family. Now, you're right, it doesn't refer expressly to this case, but that is this case, is it not? At least as it's presented, because here we have a child under the seemingly unique or certainly distinctive UK system. This child is entitled to benefits in her own right. And because of the way the benefits are structured in Belgium and other countries in Europe, particularly Belgium, she's entitled to the same kinds of benefit as a member of her father's family. This seems to, I mean, she does fit that, doesn't she? So you've got to say, haven't you, that the board's opinion is wrong. Well, let's just okay. I'll withdraw that. You've got to say either that the board's decision is wrong, or that it for some reason doesn't apply to this case.
Well, if I can put it this
I'll change my. You've got to say that either what the board there asserts is wrong, or that assertion doesn't apply to this case.
Yes. So, taking that paragraph, my Lord referred to as the building blocks, one sentence at a time. First, however, the principle of the applicable legislation of only one single member state does not preclude that a person may be simultaneously entitled to benefits under the legislation of more than one member state. Well, that, on its face, is clearly right. We know that, because that's why you have to have prioritisation rules in anywhere, and why there may, in some cases, be overlapping benefits that have to be dealt with under Article 10. But that doesn't mean there doesn't need to be a rule of priority to identify the single applicable legislation in any individual case where that arises. Now, then it says a person may, this is exactly the example that we had previously, a person may, for instance, be insured under the social security scheme of one member state while receiving from another member state in which he's not insured a benefit determined on the basis of rights which he's previously acquired in that member state.
Pension in one mistake, care allowance in another, no problem.
So that's accrued rights, and nothing here takes them away.
And then they apply that to a new situation.
Accrued rights. Then they say, likewise, it may occur to persons entitled to individual benefits in his or her own right, and to the same kind of benefits derived from the social security scheme of another member of the family. And what, I mean, perhaps it may, in the sense that a member state may make that provision. So there are circumstances they were canvassed.
So I just don't understand that. They're not supposed to. There's supposed to be one member state, isn't there? If that's the case, then the United Kingdom's done that. They don't care what happens in Belgium. They're giving it anyway. If you're saying that member states can say, well, we don't care about the regulation, we're going to have two here. You can have as much Belgian and French as you like. You're having British too. If that's the position, she wins anyway.
Well, no, then we would unquestionably be into, if that were, the Secretary of State's position in this litigation has been and remains that isn't appropriate in this kind of case.
Yeah, but they're saying it is. They're not saying. They're saying in the second sentence you can have two types of benefits for different things: pension from state A, carers allowance when you retire from state B. And then they're saying the same analogy, or by analogy, the same position applies when it's the same benefit for the same thing at the same time in two member states. One can't get away from it. That's what they say. We can't pretend it doesn't, well, perhaps I misunderstood it. But if it really does mean that, then you really are saying it's just wrong. And there's no harm in saying it's wrong. You might be right, it might be wrong, if you follow me.
But look, I'm saying, if that is what it is intended to mean, then it's wrong.
Well, what else can it mean?
I say that it may occur that a person is entitled to limited benefits in his or her own right, and the same kind of benefits from the social security system with another member of the family. That may occur perhaps in some ways.
Well, give us one example.
So, a person, an example would be that a spouse working in this country would be entitled to benefits under Article 11(3)(a), but would potentially also have the right under Article 21 because of their spouse working in Belgium. Those would arise, and then there would have to be a question of how does one resolve that. Because both are.
So this paragraph isn't really all about this case at all. They've stopped worrying about the situation in this case, where a child has got a right under UK legislation, and there's also the question that Belgium might also be the state because of family members. In this paragraph, your submission is they actually aren't worrying about that at all. They're dealing with hypothetical situations, possibly involving economically active people in different states.
But I say as well that what they're saying in the context of this case is premised on the basis that even though Belgium is primarily competent, AH could have the right under legislation of this country, which I say is not correct because that's what Section 72(7)(b) says. You don't have the right in that situation if another member state is competent.
I think, with respect, Ms Ward, you're making it unnecessarily complicated because, as I understand it, the only reason you get into the territory of prioritisation is where you've got an individual who falls within what you call the default provision or the fallback provision of 11(3)(e). If you've got an 11(3)(a) situation, which was the one you just gave us, where the spouse is working here and also has derivative rights because their partner is working in Belgium, then it's quite clear what the answer is. 11(3)(a) trumps because there's no proviso to 11(3)(a). So the answer is it doesn't matter if they've got derivative rights under Belgian law. The individual right under 11(3)(a) is the only right that they're entitled to claim. I think that's right, isn't it? So that the real nub of this is that because you're dealing with economically inactive people who weren't catered for under the previous reg, and they're there under 11(e), that's the whole reason that we've got this potential conflict between an individual right that that person gains in the state of residence and a derivative right that they get through the economically active spouse, parent, or whoever it is in the other country. And so what the Administrative Commission must be dealing with is that situation.
So if we carry on this paragraph, the likewise sentence has a footnote citing a European case called effing, which I have carefully put into Control F and in Bailey and found it. But I haven't read it in detail because, of course, that is a 2005 decision. So what? So that's, of course, under the old regulation. We might look at that if we need to. Then the board goes on to say, any ambiguity in that respect has now been removed by Article 11(3)(e), which it then quotes, and then goes on to say, the sentence we looked at with Mr. Berry yesterday, or maybe Mr. Lemaire, accordingly, as stated in recital 30, 18A, what it says. So, what this it's quite a carefully constructed paragraph, it seems to me.
My lord, if it's helpful, we're getting copies of effing
Yes.
and the Advocate General's opinion, which the paragraph
Well, I
39
was about
refers
to
brought over to court.
I was about to come to that to Ms. Ward. Following the footnote, the next footnote after the effing footnote is the footnote of which supplements the next sentence about citing Article 13, 11.3e. So, which I haven't put that yet. So that's what it's saying, isn't it? That you, the likewise sentence is, it seems to be is an unambiguous assertion, Ms. Ward, and it re-emphasises the point against you, it would seem, because it says, insofar as there was an ambiguity under the old law, based on the effing decision, it's been removed by the redraft in the new regulation. So this paragraph is, I think, against you.
It is dead against you, I think.
So, I'm not myself clear. Are you saying it's wrong as a matter of exposition of the law, or are you saying it doesn't apply to the facts of this case, or both?
Well, what I am saying, my primary case is that the reference there to may be entitled to benefits in their own right on the basis of residence is a reference to cases such as those referred to in when we were debating this issue before the Upper Tribunal, and that my lords and lady will see that in section G of the Upper Tribunal's decision, beginning on page 54 of tab 4 of the bundle.
I'm so sorry. Which paragraph, Ms. Ward?
So that's section G. So beginning.
Yes, I see. 37 onwards.
So that's about, firstly, about section 72(7)(b), and Mr. Berry, you see at paragraph 38, argued that it was contrary to EU law because it would disadvantage dependent and mother compared to cases in which a family pursues all activities in a single state. It's not so much that section as then at section H. The discussion of cases in which it may theoretically be that member states can make provision where they're not the competent state for a particular class of benefits, and that's in particular paragraph 43 on page 56. Towards the end of that paragraph, the quotation from the not a language that I can claim to be able to pronounce, Ministerstvo Praceje Sociale Interveci.
The B case.
The B case, yes. And if there are specific and particular close connecting factors between the territory of that state and the situation at issue, on condition that the predictability and effectiveness of the application of the coordination rules are not disproportionately affected. Now, the Secretary of State's position, and it was agreed with by the Tribunal in this case, was that that would be the case if the UK made provision in a situation where Belgium was competent. We don't need to establish that. In my situation, we didn't need to establish that to succeed before the Upper Tribunal on section 72.7b issue, it's sufficient that the UK is entitled to have that provision. But the conciliation board may have been proceeding on the basis that the UK was not required to have such a provision, and indeed didn't have such a provision, and did commit benefits solely on the basis of residence, even where another state was competent under the regulation. And it's saying you're not precluded from doing so. Now, we don't agree with that. It doesn't rise for determination because, firstly, there's no appeal on that issue against the Upper Tribunal, and secondly, because in any event, there's no suggestion the UK isn't entitled to have that provision.
So, in answer to my last question, just so I've got a note of the submission, the third paragraph on page 155 is simply not addressing the question in this case. Is that what I should write down as your submission? I'm just trying to understand what your submission is.
It's not addressing the situation in this case on the basis of a full understanding of the UK domestic legislation.
Right.
Does that amount to a submission that she doesn't have an independent right under UK law because UK is not the competent state?
Well, she ultimately doesn't have that right because
Well,
state,
ultimately, I don't see what ultimately adds to it. Either she has that right or she doesn't. Because I understood it was common ground that she had an independent right. Now you're saying that the domestic legislation takes it away because the UK is not a competent state.
But I'm saying that the domestic legislation doesn't provide for any benefit that might otherwise. I'm saying she potentially has an independent right. She may have an independent right to other kinds of benefits that are not cash sickness benefits covered by Article 21. So yes, she does have an independent.
It becomes a little circular, doesn't it? It becomes slightly circular. You start with the position that she does have an independent right, undoubtedly under UK law, because prima facie, as a place of her residence, UK affords her that right. That right is then said to be without prejudice to any guaranteed rights given by the rest of the regulation. So you look at Article 21 and that says, well, that guarantees you a right under Belgian law. Belgium, because of that, you say, Belgium is the state of priority, and that is then the only competent state, which means that you take the right away under domestic law. But if Belgium is the only competent state, you don't need Section 72. You don't need any domestic legislation at all. So why are you relying on it?
Well, maybe the Secretary of State's position is that you don't need Section 72.7b, it simply restates the position. But that is a matter that was contentious before the Upper Tribunal, wasn't contentious, or wasn't debated before the Conciliation Board because not part of the issues in the appeal. But as you see at paragraph 43 of the Upper Tribunal's determination, there are circumstances in which there may nonetheless be a right under domestic law in a state which is not the state that has been.
So the Section 72 point is merely being put in to knock down a non-point, which is that there isn't in fact a positive enactment by UK law that confers a right notwithstanding the priority given to Belgium. That's what it really amounts to. But you don't need it. You don't need it at all because if you are right in your analysis that Belgium knocks out England, then Belgium knocks out England and you don't need to look at the domestic law.
But, my lady, the Secretary of State's position is that is right and you don't need Section 72.7b. But that has been contentious was
Right.
argued before the Upper Tribunal. There are circumstances in which provision can be made, even though the member state, the UK is not a property member state. That's what was considered by the Upper Tribunal at paragraph, set out by the Upper Tribunal at paragraph 43 in certain circumstances. Okay. So the Secretary of State's position effectively is that Section 72(7)B is an avoidance of doubt provision. But equally, if the arguments that were advanced to the Upper Tribunal about entitlement or requirement to make provision in this situation were correct, then Section 72, entitlement to make provision in this situation is correct, then Section 72(7)B will be confirmation that the UK does not exercise its entitlement in that respect.
My lady, yesterday I handed up an explanatory memorandum that explains the purpose behind these provisions.
Did you actually hand it up?
I did, yes.
Okay.
And if you look at paragraph 7.5 of the explanatory
Well,
memorandum,
I wonder whether this is something we might look at with you in re-examination.
I'm great.
We're giving Miss Ward quite an intense time with our interventions, and I think, in fairness to her, we'll let her do without further respect, Mr. Liver, interruption from you at this point.
Well, the explanatory memorandum says what it says, and it was enacted in a situation where Section 72(7)B was enacted in circumstances where it had been decided, as Mr. Mayor explained to you yesterday, that certain types of benefit that it had not understood to be exportable were exportable. And the UK's response to that was to put in an avoidance of doubt provision to ensure that no one who wasn't entitled to the benefit strictly got it. That's not what, in terms, the explanatory memorandum says, because one wouldn't expect an explanatory memorandum to be maybe quite so blunt. But that's the background there. And so there's nothing in the explanatory memorandum that's inconsistent with that. So I maintain the submission that I've just made in response to my lady, that insofar as the UK could provide benefits of domestic legislation in circumstances where the member state was competent, it has decided not to do so. The Conciliation Board has taken the view that it would be entitled to do so. We don't agree, but that wasn't an issue before the Conciliation Board and isn't an issue in this case. The fact in what is clear in this case is that the UK has decided not to do so, and therefore, in circumstances where competence under the regulation devolves on Belgium, there is no entitlement in domestic law, as was envisaged by the Conciliation Board. Now, insofar as the Conciliation Board is saying something different and is saying that there can be entitlements under, so there can be more than one set of applicable legislation in any given case, then I do say that that's not correct. That the situation envisaged in the previous sentence before the likewise sentence is not about more than one applicable legislation for the purpose of claiming benefits. It is about rights accrued under different sets of legislation and how one then sorts that situation out. And that's wholly different to a situation where there's no rights accrued. There's only a right under 11(3)E, which is without prejudice to, so the residual category without prejudice to entitlements under other parts of the regulation, and in circumstances where there is provision made under other parts of the regulation and the residual category isn't needed effectively. So in this situation, there isn't. The 11(3)E right doesn't enable the appellant to be entitled to benefits in this country, if I'm right, of course, on the prioritisation. So for how you prioritise. But I do say there is and remains a need to prioritise, and that was recognised in the first part of the Conciliation Board's opinion. And the Conciliation Board, as I say, has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK has decided not to do so. And therefore, the UK Article 10 and what is the role for Article 10, which is anticipated was the challenge to my position from my learned friends yesterday, is, well, if there are, in the situation where the UK had chosen to make provision in this or a similar category of case, then Article 10 would have a role.
I still don't understand how, if you've got a coordination system based on a single member state, you can say under EU law that single member state is Belgium. Nonetheless, if I choose, you can have a different and separate benefit as a matter of English law. Either that's what Article 11 allows, or it doesn't.
Well, as I say, it's not been part of the debate before this court because there wasn't an appeal against that part of the Upper Tribunal's decision, but the principle is set out in my submission quite clearly in paragraph 43 of that decision, and the case law underlies it. I don't know if this assists my lord, it has on occasion assisted me when grappling with these cases, that sometimes the search for meaning is what drives one mad.
Is what?
Is what drives one mad.
Yeah, right.
Well, if that was the case, then the whole of all members of this court would be parted off.
Don't go there.
I don't just mean the three of us, I mean all 39 of us. Because that's what we do all the time, search for meaning. So you say paragraph 43 is where there's the failure to challenge the Upper Tribunal's section H, is that right?
Well, I'm going to say that there isn't a challenge to it. Now, I don't say it's a failure to challenge it. I'm saying that's perhaps why it hasn't featured in the argument in this court. But I do say that's a part of the overall motives of this case that didn't make its way into the conciliation board. The conciliation board appears to have proceeded on the basis that the UK was saying, well, there would be a domestic right if there wasn't for Article 21. There would be a right under domestic, so there would be a,
But they would.
yes, yes. The UK was
We're back to square one. There would be a right under domestic law if it weren't for Article 21. It's the fact that there is Article 21 that gives rise to your argument based on the without prejudice proviso.
That there, I'm sorry, that there could be a right in domestic law if it wasn't for the priority of Article 21.
Yeah.
That's the point.
That's what I find very baffling, because what's the point of having a priority rule if you can derogate from it domestically?
Well, you can, as I say, my lady, the Secretary of State's position is that you couldn't on the facts of this case, but it wasn't debated before the conciliation board. They haven't decided that you necessarily that you could, because they certainly haven't heard argument or representations on whether you could or you couldn't, and because that simply wasn't an issue before them. That there are limited circumstances in which it is permissible, and those are set out, as I say, at paragraph 43 of the Upper Tribunal decision. So it's not a general, you can derogate in any circumstances. There has to be specific and particularly close connecting factors, and no impact or no disproportionate effect on the predictability and effectiveness of the application of the coordination rules. Now, the Secretary of State's position is that neither of those would be met in this case.
Well, residents, for benefits intended to pay the costs in that state, generated by disability in that state, wouldn't affect anyone else. Nobody else has our system. Sounds as if it's absolutely perfect for it.
That's why it was an SNCB.
Well,
My Lord,
Anyway, but I take your point. But you say even if it could meet it, they chose not to. Is your point?
I understand my Lord's view as a matter of impression, but there are difficult and technical arguments in that field which are not before this court.
Right, so I don't know enough to be worried about it. I shouldn't worry about it because I don't know enough to know how worried.
don't worry your head about it.
If it assists, I mean, my Lord is aware, as previously referred to, the expertise of Judge Jacobs in this field, and those paragraphs are fully consistent, said by him to fully consistent with what he said previously. And he has considered section 72(7)(b in detail. subject to any other fiendishly difficult questions, those are my submissions on the need to prioritise.
Yes.
And if I may, I'll move on to how one conducts that.
Yes.
The court's already seen how the conciliation board approached that exercise and effectively saying, well, there are two ways you could do it. These are the advantages and disadvantages in this particular case. And these are the alternatives that could be adopted by an interpretative decision or otherwise. As my Lord Justice Lewis said earlier, that interpretative decision not having been adopted and no other steps having been taken under this procedure, that is the issue that now comes before this court, and that you do have to grapple. And I've hopefully been relatively brief in my submissions on this point, because what I've said in writing and broadly what was accepted by the Upper Tribunal, that the entire scheme of this regulation, this was of course common ground before the Conciliation Board, is the prioritisation of rights based on economic activity. And that's the context in which I referred to Articles 32 and 68, which you were taken through at some length yesterday. I won't take you back to them. But in both of those cases, neither of which, of course, are directly applicable here, the starting point is the priority of rights based on economic activity, which is also, and this was what swung it perhaps for Judge Jacobs, consistent with the scheme of Article 11.3.
But that only works if there's one state of economic activity. If there are two, you then get into deeply uncharted waters, because you've got to prioritise one of them, and that means that you're not necessarily going to get everything under one umbrella.
Well, you do, my lady, and that's not an issue that arises in this case, as Judge Jacobs acknowledged, and in cases where it's most likely to arise, the regulation has made provision for it. So, for example, in Article 68 in relation to family benefits, which of course is a somewhat different concept, because it's about members of the same family but having individual rights, meaning that the family overall ends up with overlapping benefit entitlements. There is a prioritisation, firstly on the basis of economic activity. Then, if there is economic activity in both states, or more than one state, the state of residence of the child, if there's economic activity there. So, where it's thought likely to be needed, the regulation does give an indication of how that should work. But all I say is that where you have, very squarely, where you have one right based on economic activity and one that isn't, that the question of prioritisation is far less complex.
Can I just check Article 32? What you say it means? 32.2, is that the situation in this case, that where you're dealing with members of the family of an insured person who reside in the United Kingdom, where our legislation does not make the right to benefits in kind subject to conditions of insurance or activity? Benefits in kind should be provided at the expense of the competent institution in the member of state which they reside. For benefits in kind,
Well, my Lord,
this is 32.2, is it?
my Lord, yes, but that's if the spouse or the person caring for the child of the insured person pursues an activity as employed or self-employed person in the said member state.
Where the members of the family reside in a member state under whose legislation the right to benefits in kind is not so usually. If the spouse pursues
So So if the mother goes and gets a full-time carer to look after the child and works in this country, one result obtains. But if she stays at home to look after the child herself, another result obtains.
In relation to Article 32, yes. But it's not only if she gets a full-time carer, it's if she goes out to work in a non-negligible way at all, so for 5 hours a week.
I don't understand at the moment, and it is entirely my fault. I've read it dozens of times now. I just don't understand, and maybe I've got to sit down and work through 31, 32, 1 and 2. I've now lost a little to live. I don't know what they mean.
It's a very bad sign for various reasons.
Where the members of the family of an insured person, so let's put it into this, where Amira, where Amira resides in a where Amira resides in the United Kingdom, which is a state whose legislation gives the right to benefits in kind, but not subject to conditions of insurance, the United Kingdom institution in the member state in which they reside will be competent. And the words, if the spouse or the person caring for the children of the insured person, what does that, from the words if to self-employed person do, what is that actually doing? What's it qualifying? Because if I stop there, the family member would be the child and everything would be fine. So what is the purpose of the words, if the spouse or the person caring for the children pursues an activity? What is that even doing grammatically?
Well, that presumes that the insured person is an adult, doesn't it? Got to.
Yeah.
So it only applies if you look at the first sentence, where the members of the family of an insured person reside in a member state. So that's, let's say, dad. Where the members of the family of an insured person, dad, reside in a member state under whose legislation the right to benefits is not subject to conditions, benefits in kind shall be provided at the expense of the competent institution in the member state in which they reside, that's the UK. But if the spouse or the person caring for the children of the insured person pursues an activity as a self-employed person in the said member state, etc., that is assuming that the insured person is the father in those circumstances. But if the insured person is the child, then I can't see how this article applies at all.
Well, exactly. I mean,
my submission isn't that this article applies. My submission is that this article shows the general scheme.
no, I understand that. But because it shows the general scheme, and I'm just trying to understand, if Amira is getting benefits in kind in the form of health treatment, could you please explain to me how the United Kingdom is liable to do that under Article 32? Which words would mean that it's the United Kingdom, not Belgium, that means she's got to have the benefits, or is it the Belgium that must give her the right? It'd help me understand how the cash benefits work, because they were originally both dealt in the same way in the original legislation, and they've separated them. So if I understand how benefits in kind are provided under 32 on the facts of this case, that might help me.
My Lord, the answer is that this is the paragraph of the Conciliation Board opinion that was skipped over. That technically the United Kingdom considers that it is entitled to recover from Belgium the cost of the healthcare.
Right, but could you just go through 32, please, and just explain to me which words on that page cover Amira, Belgium, England, so I can work it out. Do I start with Article 1 or am I in Article 2?
Start with Article 1.
Yeah.
Article 2 qualifies Article 1. Firstly, an independent right to benefits in kind, basically that it will take priority over derivative right to benefits for members of the family.
So that sounds to me as if it sounds, before I got to the next sentence, if I'd stopped there, I would have thought, well, the independent right of the child, based on the legislation I member state, takes priority over her rights to the member of the family. That's what I read in sentence 1. And then I go on to sentence 2 and you say...
But where the independent right in the member state of residence exists directly and solely on the basis of the residence of the person concerned in that member state, so it's an 11.3e right, the derivative right to benefits, which by definition is a right based on economic activity under 11.3a, b, c or d, will take priority.
Right, so does that mean or does it not mean that in this case it is Belgium that must provide the benefits in kind for the child?
Yes.
So under
That's
Article
paid for and provided, as discussed yesterday, in the case of benefits in kind, they're always provided in the member state of residence.
well, and where's that from?
That, well, firstly, I'm not sure it's, there were words in the regulation.
If she went to hospital and she said, I'd like hospital treatment, please, and the receptionist held up Article 32(1) and said, no, you can't, look at that, Amelia would pull out of her satchel which article and say, aha, it's this one.
Article 17.
Article 17.
That's page 99 within tab 11. So an insured person or members of his or her family who reside in a member state other than the competent member state shall receive in the member state of residence benefits in kind provided on behalf of the competent institution by the institution of the place of residence.
Right, okay. So 32 then is just
So 32
a
is
financial
about
mechanism.
And you would say that 32.2 is an exception to 32.1. So 32.1 points to Belgium being responsible financially. But if mum went out to work
Yes.
for the relevant period,
Yes.
then it would be the UK, the buck would stop with the UK.
Yes.
That's effectively what 32.2 does.
Well, in that case, why doesn't 11.3e do the same as Article 17, and there's no payment mechanism switching it to Belgium? We've assumed, I was assuming that 32 was the thing that switched it to Belgium, but it's the reverse. The right is 17 and costs are switched to Belgium. So why isn't the right to the benefit in 11.3e and there's nothing to switch it to England? To Belgium. It's only 21 that switches it to Belgium then, is
It's
it?
21 that switches it to Belgium.
The 21 has got to, on your case, be performing the same purpose of Article
No.
30. Ah.
No.
The person who receives a pension or pensions and who is not entitled to benefits in kind
Only relates to pensions. Okay, no, it's a bit misleading, Article 24. That's sort of doing pensions, it doesn't
at the moment. So 17, what's going through my mind, just so it's clear what I'm saying, 17 gives the right to benefits in kind from the state. It's 32 that switches responsibility to pay to elsewhere. And I'm thinking, well, where's the equivalent of 17 in the legislation? At the moment, I've only seen 11.3. And the problem is, from the state's point of view, what's the one that switches it?
Well, I certainly had in mind that there was an issue that engaged Article 32, and that's what was being debated in the Conciliation Board's opinion
Don't worry about the opinion or the
When it
tribunal.
talks about
Let's just work from the
documents, that's
legislation
fine.
as if none of that had happened and we've gone back to basics.
Yes. So,
Well, isn't the language of Article 17 mirrored in the first paragraph of Article 21? Or at least to an extent.
yes. Yes, my lady is right. I was trying to keep a lot of moving parts in my head at the moment.
I'm trying to help.
My lady is absolutely right about that. That.
But that says an insured person and members of his family residing or staying in a member state other than the competent member state.
That's exactly, as my lady says, exactly the language of Article 21.
Well, not quite. Article 17 says shall receive benefits in kind, provided on behalf of the competent institution, whereas Article 21 says shall be entitled to cash benefits provided by the competent institution. So it's like there is a difference.
Okay, my
in
lady, it
language.
also says or rather than and in an insured person or members.
Yes.
Can I take a step back, Ms Ward, when you reply to Milady, and I want to move on. Let's take a step back.
Well, I'm very keen to take a step back.
Okay,
Because I've
okay.
gone down and-
Can I take a step back to the meaning of insured person? Is a mirror the insured person? Should we take a step back and go back to?
So you're let's talk about the purposes of.
No, I'm going back. I take a step back. So let's take a step right back and go back to Article 1 of the definitions. Does she come within the definition of an insured person?
For
Well, just for the purposes of 1. So what 1C says, an insured person in relation to the Social Security benefits covered by Title 3, Chapters 1 and 3, okay, means any person satisfying the conditions required by under the legislation of the member state competent under Title 2 to have the right to benefits, taking into account the provisions of this regulation. So is she an insured person?
Well, she is an insured person for general purposes, and yes, she is
All right.
entitled to some benefits under the legislation of the UK.
So she is an insured person,
Yes.
and simplistically, it's part of the scheme that she has an independent right. Okay? So if we go back to 32(2), we find the phrase insured person there, used with a qualification. 32(2) says, when the members of a family of an insured person reside in the member state under whose legislation the right to benefits in kind is not subject to the conditions of insurance or activity as an employed or self-employed person. So she falls into that category, doesn't she? She is an insured person whose right is not subject to conditions of insurance or activity as an employed or self-employed person. That's what she is. She's not, okay. So I think that gives some clue that insured person is intended to cover, not just to cover to uncover people like Amira. So if that's right, is she an insured person under Article 21? Is she the insured person, Article 21? Shall I rather than lead you just say yes or no, just show you where I'm going with this and tell me where you think I'm wrong. If she's the insured person, all right, then the competent institution, being the institution with which the person concerned is insured, is the DWP, and the competent member state, being the member state in which the competent institution is situated, is the UK. So under Article 21, which provides an insured person residing in a member state other than the competent member state doesn't apply to Amira because she's resident. She's not resident. She's resident in the competent member state.
That's exactly right. She doesn't have an independent right under Article 21. She has a derived right under Article 21 as a member of her father's family.
Well, no, just a moment. If she's an insured person, 21 only applies where an insured person resides in a member state other than the competent member state. So if she's the insured person, then the competent member state is the UK, so she's not residing in another member state.
Yes, absolutely, madam. For the purposes of Article 21, she could be an insured person. If she was
living other than the United Kingdom.
She was living outside.
And she isn't.
She isn't. Yes. So, and my lord, what my lord has just said would have directly the problematic consequence that I talked about yesterday in relation to a slight tweak on the facts of the Hosser case. That then there would be potentially no entitlement for a person left behind in a state where rights depended on active insurance.
Just take another sad set of facts. Both parents are tragically killed. She can only claim the United Kingdom there. Yes. So we're all here. We say because there's one, she's the insured person. She's entitled to the benefits. If her parents have sadly died, she continues to be entitled to the benefits. And the only reason why it's switched is because the father's gone to work in Belgium. That's it. And and the reason why it's switched must only be because 21 now applies, and it's implicit in 21 and implicit in when they made the new rules that was the intention, was to switch it.
Yes, but she then has a derived right under Article 21.
In addition to her individual right.
That I say takes priority over the individual right because there's a need to prioritise because there can only be one applicable legislation.
And there are two options. You're right, and it's Belgium. There's another option. You're wrong, and it is priority, but it's Britain.
Yes. So how do you prioritise? That's exactly the issue. And as I've said, under the regulation, and I say including, particularly under Article 32, and this isn't about the application of Article 32 in this case, it's about what priority article, whether it's engaged or not, it's about what priority Article 32 gives to rights from different sources. Okay. And the first paragraph of Article 32 finds that ordinarily an independent right will take priority over a derivative right. But if and I think perhaps the answer to my last question where we ended up getting a bit circular a moment ago is that what's being discussed here is whether there's a derivative right to benefits for members of the family.
So you're about to finish a very important sentence. Article 32 means the priority is switched where, and it's switched where the benefit is residence only, and then it switches to the economic state, is what I thought you were about to say, but I just need to make sure that I've understood what you're saying.
It's saying that it's saying that where members of a family have a derivative right to benefits, ordinarily their independent rights will take priority over that derivative right. So this isn't about Article 21, but in the Article 21 example.
Yeah, but let's take a look. Where the independent rights exist, they normally take priority over derivative rights, except where
the independent right in the member state of residence exists directly and solely on the basis of the residence of the person concerned in that member state. So where it's 11(3)(e). Only.
Yeah. So this is an odd situation then, when benefits in kind for somebody who are resident switch to the state of the economically active person. And you're saying this is actually the same case then?
Well, I'm saying that if
if
this
that's what
rule
happens
was
to
applied,
32,
yes.
if 32 had existed and had applied, then they would have switched not just the benefits in kind. If they'd ever thought about it, they would have switched the cash benefits as well.
I'm saying that the scheme that Article 32 provides prioritises rights based on economic activity over rights based solely on residence.
Even for benefits in kind, yeah.
Well, for benefits.
Or for benefits in kind.
Only for benefits in kind, that's all it applies to.
Yeah.
But it is an indication, because it's one of the provisions in the regulation that makes express provision for priority in particular situations. It is an indication of the scheme of the regulation, which is to prioritise economic rights based on economic activity. As I say, common ground before the conciliation.
But the benefits in kind have got to be provided in the member state.
They have to be provided in the member state.
And presumably the person who provides them in the member state can then recoup them under 32,
Exactly.
is it?
Exactly.
And
that's
hold on, so
because-
rights under 17 and then recouped under 32. I'm still, and it really is my fault, I'm then trying to envisage the situation here for cash benefits, now not benefits in kind. And that's why I say, what piece of paper, what article does she rely on to get the cash benefits, and what's the piece of paper that says the person who will ultimately pay the amount of the cash is X. And she's only got the right to the cash benefits, that she can only have them provided in the United Kingdom at all because of 11, yes.
So if
So
this
you've
were-
got to say then that 21 is the thing that does the same purpose as 32 and says although they're provided in England, they'll be paid for by Belgium.
But what I hope it's slightly more subtle than that.
Right.
But it's that there needs to be prioritisation. That's a general.
Well, she's got two sources of benefit. She's
Yes.
got the rights to cash from England and she's got the right to cash from Belgium,
Yes.
not right from England recouped by Belgium. She's got the right to benefit from England, but because there's Article 21, the right is switched. Not the ability to recoup from Belgium, but the right is switched. And if she goes to the DWP office in England, she'll be told, I'm terribly sorry, you must ring our cousin office in France. Not, oh, I'll pay you and I'll see if I can get the French to hand over some grubby euros. You say the right is switched by 21.
I do. Well, if I can just pick up on one point there, because it's not you have to go off to Belgium, it's
No,
the
right.
UK must notify Belgium.
But I
So
mean,
the UK passes.
21 is doing an awful lot of work without any clue in the language, isn't it?
Well, moreover, it's effectively depriving somebody of a right that they would otherwise have.
Well, and you're right, I would suggest that it also, at the same point, provides, because I think we've agreed
Yes,
a few minutes ago
she's got a right
that
to.
she's the insured person.
Yes.
On one interpretation, she has an independent right under 21 because she's the insured person, and and therefore your client, your minister is the competent authority. Therefore, she's not residing in a state other than the competent member state. So,
Yes, so to ask for-
and then how does, if that interpretation is right, why isn't she also entitled under 7B? Because under 7B, she's entitled if the UK is competent, which it is.
But not under Article 21.
Yeah, she doesn't get an entitlement in her own right under Article 21, but she's not living in different member states.
Exactly.
But the oddity here is that there's no provision for recoupment from Belgium, as there is for benefits in kind. There's no guarantee that she'll get it immediately in Britain, because Britain don't have to provide it and recoup it. So the oddity here is, the moment her father moves to Belgium, she loses the ability to enforce the right that she previously
Yeah.
had.
Yes.
Yes.
My lord,
That's the
yes, it
position.
counts
That is the
those
position.
2 points. firstly, in relation to recoupment, that's a specific benefits in kind issue, because for all the reasons discussed yesterday, a person needs to be able to access healthcare where they are and on the same terms as everyone else there, and then there has to be provision for recoupment. And in relation to the losing of the right, of course, there is the provision that, and I accept belatedly that there is the provision that came into play in this case under Article 6 of the implementing regulation. But if Belgium did not accept, as it ultimately did not, its responsibility, that the UK is now, at the present moment, providing the benefit on a provisional basis.
Yeah, but until we accept your arguments and say that she shouldn't have them. But the oddity here is not only is she losing the ability to enforce the right in England, by virtue of her father moving to a state where there isn't a right in Belgium, she loses the right to sickness cash payments at all. And it's not a priority rule in that actual scenario. We'll say, no, that's just unfortunate. But it's not performing the equivalent of a reimbursement from Belgium. It's an extinction of the right.
Yeah, extinction of the right. Unspoken. It does seem quite a big thing to be extinguished without being expressly set out.
Identification of applicable legislation for the purposes of AH's rights to sickness benefit, cash sickness benefit. Okay, and the scheme of the regulation, my submission, is that she has a derivative right from her father that there can't be on this sort of as concurrent competence, concurrent applicability under the regulation, because that is inconsistent with the scheme of the regulation, which requires a single applicable legislation to be identified. And that therefore there is a need to prioritise as between the potential, the right to claim. There's a right to claim a benefit, not a right to receive a benefit. In order to identify the legislation that is applicable to her, the state that is competent for paying for this type of benefit, one has to choose. One has to say the scheme of the regulation, which requires there to be an answer to that question, has to provide a mechanism for identifying which it is. It can't just be left to, well, could
And
be
it's not
residence.
express, so it's got to be implied.
It's really implied.
But why can't we imply it as the state of residence? What are the factors that say it's better to imply the state of economic activity of the parent and to have read into this a switch, and indeed in this case extinction of rights, rather than a simple the left of the state of residence as it used to be in the past?
Well, I say, first, and I think you have my submissions now, that overall, in general terms, the rights based on economic activity are prioritised. And for that, I rely upon, as I say, the way that works under Article 32 in relation to benefits in kind. I don't say it's applicable, I say it shows...
By analogy.
I say that Article 68 in relation to family benefits shows the same. And I quoted in my certain argument from the textbook on this subject by Franz Hennings, which has been updated since then. The 7th edition came out towards the end of last year, so I provided my learning friends with relevant papers that shows that the general principle. Professor Hennings has taken to heart Judge Jacobs' indication that Latin is not useful in this context, and he's asked us to talk about the principle of the state of employment as opposed to the lex loci laboris. So to that extent, the quote is slightly different now, but the point that's made.
The point is the same, but in English.
You've
now got to the stage.
So
in order to win, it's the recital and the scenario that says it's really the economic state of activity of the parent.
I say that the recitals 15 to 20 support that, and I say that actually, given that one has to look at this regulation as applicable to the EU as a whole, that firstly, the way that the fundamental rights, for instance, the very fit it was put below was effectively you have to choose an individual case, and I say that's
We're not there. Yes, he's not arguing that now.
Mr. Lemaire now says that the rights of the child point in favour of it being the state of residence. I should say, and this is paragraph 16 of my response to Mr. Lemaire, page 141, I've never disputed that general principles of EU law require taking into account the rights of the child.
Yeah.
But I say it's a non sequitur in this case, because you need to have a rule, and if Mr. Lemaire says, well, that rule should replace residence, that is going to be enormously problematic in the vast majority of member states, the Hosser example, where that depends on someone being economically active in the member state of residence. So, on a holistic view, the rights of the child can actually point in the opposite direction in my submission. Now, in individual cases, there's no guarantee that moving around the union will be neutral in terms of benefits. So there will be, like I said, in that hard cases, if a reference is needed for that, it's the Drusilla Martin's case, which referred to in the Upper Tribunal's decision at paragraph 39 in the bundle at tab 22. And I do also say, in answer to my Lord's point, well, why isn't it the same as it was previously? That was special provision then previously. It could easily have been replicated.
But on one analysis it has been, because they've put it into 11.3 and they haven't put anything in to switch it anywhere else. I'm still hung up on that I'm looking for something that changes it. And at the moment I thought the argument is different, but here we've got to imply the change.
Well, you've got to imply the overall scheme of apply, but to interpret the overall scheme of the regulation without that provision.
There's no express alteration of the priority rule under 19.2. Because it's changed and you've now got insured persons rather than employed persons, the thing that you needed in 19.2 to give the person this right benefit in the state of residence is now 11.3. And I've now got to look for something that switches it. And there's nothing expressed to switch it. So I'll then say in horror, well, does that mean that there's an implied switching? That, I think, is where we get to.
Well, I think Miss Ward would probably say that the switching is in the words without prejudice to other provisions.
Yeah, but if that were right, Miss Ward, one would surely expect it to be expressed entirely differently and much more clearly.
Yes.
I mean, what one would expect it to say would be to use the same or similar terminology in the first part, in all parts of paragraph E. It says, wouldn't you expect it to say, any other person to whom paragraphs A to D do not apply shall be subject to the legislation of the member state of residence unless ... Or it's apples and pears. There's the two parts of subparagraph E, isn't it? It reads if it's giving that person additional benefits without removing them from the legislation of the member state of residence. That's how it reads naturally. It doesn't, to me, read naturally as saying that if they get other rights under other provisions of regulations, then they're not under the legislation of the member state of residence.
My Lord, I go back to my very start of my submissions on the previous question, which is about there being a need to prioritise when there are competing potential rights, because 11.1 identifies that there needs to only be one
We've got that.
legislation. So,
And the question is which state now? We've got prioritisation. That tells you it's got to be Belgium, it's got to be Britain. It's got to be one of them. And the question is, why isn't it Britain?
and I'm not sure whether I can take that submission very much further.
No, then what do you want to
Because I've
It's
said-
really the economic activity is
The
prioritised.
scheme of the legislation prioritises it, that if the priority goes to state of residence, that will disadvantage at least as many, and probably considerably more, children than it advantages, because of the insurance-based systems it's operating.
Yeah, but we don't know about that. And then swings and roundabouts and so on. They may have social assistance, as Mr. de Lamar said. But from our point of view, at the moment, it really is the economic system. The system is based on economic actors prioritised.
And it is, and I say that's the general scheme of regulation, and it would have been very easy to depart from that by having a provision similar to 19.2, by inserting in Article 21 words along the lines of unless benefits are provided by the member state of residence under 11, or unless there's a right under 11.3e, but that wasn't done.
Well, if a father goes to work, as often happens in another country, for a period of time, then comes back. So say he goes to work in Belgium, seconded to work for the European Commission or whatever for 9 months. For that 9-month period, would someone in a Amira's position cease to be entitled to cash benefits in the UK, and then when he comes back, her entitlement would revive, would it?
I think that would depend on whether the father becomes an insured person in the member state in which he's working.
And if he does?
And if he does, then yes. But then that's inherent in the scheme generally.
It's not exactly an incentive to free movement of workers, is it? If you're the parent of a disabled child and that child is reliant on cash benefits, it's not a question of recoupment of benefits in kind, which you'll get anyway. To know that if you go and work abroad and become an insured person abroad, that child is not going to get the benefit.
Maybe it's very much the swings and roundabouts issue that may be the case. It appears to be the case on these facts.
Well, if the child is in Belgium and the father came here,
yes,
then you would say that the care component would be paid to the. You would say just turn this fact around.
exactly.
Your answer.
Or if the father had gone to work in a member state where there was more generous,
Yes.
then the appellant would be entitled to benefit from that. With them.
Yeah.
So it's not neutral to Silver Martin's point. There will be advantages and disadvantages, but maybe it's certainly not an incentive to freedom of movement if you're German. Say that if you go and work in another member state, your disabled child is only entitled to benefits based on her residence in Germany, which are non-existent if there's no economic activity there.
I mean, broadly speaking, Europe, countries of Western Europe provide levels of support for children like Amira, but they provide it in different ways.
And that's where many of the difficulties
But then it'd be social assistance, as I understand it,
Yeah.
rather than social security.
Subject to residence.
Or what do they call it? Is it social
Social assistance,
Yeah.
most of which is subject to residence.
Yeah, I mean, Miss Moore, we've really. You thought you were obviously expecting us to be interventionist, and we have been, and I hope you understand that that's why we do, because it's a very difficult job. And my Lord, once you've even got my Lord to say he lost the will to live,
No reflection on you.
Or the contrary, I think is a reflection of the strength of your submissions. I'm very conscious that we've interrupted a lot. I would like you to have every opportunity to say whatever you want to say. So is there anything, how far have we got?
My Lord, other than anything that those behind me wish to say, and I'm going to ask a moment to turn my fan,
Yeah.
I think I am finished. So all you have is, almost literally. All you have, I think, is whatever arrangements, well, any friends are free between them to reply. But may I just turn my fan very briefly?
Yeah, I'm going to ask over it now. So
The domestic regulations setting up issues.
Exactly. Yes, we haven't got that. It's not like they were handed yesterday.
We've got a bit of them, I think.
Yeah.
We might
Right,
have
Jennifer,
to
I've got
an
more.
extra.
If you have
all
got
of them.
No.
No.
Yeah, okay.
Absolutely.
I would
Yeah.
urge my lord, my lady, if possible, not to say
Anything just in case.
about it, because I may bring in various other arguments. My lord, I've made my submissions. It's down to this court to interpret this regulation in the way that maintains the integrity of the scheme of it, and in my submission avoids confusion by avoiding the applicability of more than one state's legislation. My lord, my lady, unless I can assist you any further.
We would be assisted if we've not got it already by having the regulation which sets out the specific conditions for the entitlement of this benefit.
Of DLA.
Yeah. We've got something, the bit that says you can appoint the parent or a parent. But I'm thinking things like, you get it if you're under 16 and you're, you know what I mean?
It's under 16 and there's the standard HRT test.
Whatever it is, but just a piece of paper with the words on it.
Yeah, we'll get that.
In this sea of uncertainty, a piece of paper is so reassuring.
Well, much of the ground is covered in section 72, which is the enabling provision.
Yeah, but there must be a regulation that says if you're under 16, and if you're A, B, and C, and if we're feeling generous, you have the following calculated by this thing. It's just that piece of paper, really, that regulation or regulations must mean something.
Like the middle of section 72 is pretty detailed, and it does provide for certain matters to be prescribed, so we'll ensure that the court has everything that is prescribed.
So it's 72. So it's 72 of the Act itself, actually, page 9, but some detailed regulations underneath it.
So you like those?
My lord,
Just to make sure we've got everything.
We'd like that if we.
Yes, I mean, so for example, by subsection 3, 3 weekly rates for care components should be prescribed. So there are regulations that prescribe the amounts.
Would you like those?
Well, and the amounts might be useful, because that might give us an idea as to whether it's linked to the state.
I think if possible, Ms Ward, could we have those regulations? It may not help, but it would be just to get the full picture.
Yes, there's 1 or 2 references to regulations, so I'll find what there are and send them all.
Yeah, that'd be useful. And the 16, for example, that comes, or under 16, that comes under 1A. It's got to be in relation to a period before he reaches the age of 16. So that's where I get the 16 from.
Yes.
And I'm presuming there's something here that says you've got to be residing in the United Kingdom, isn't there?
There is.
Subsection 2, I think.
Section 2, is it?
That's the fairly standard HRT test.
I hate abbreviations because you know what they mean, but I haven't a clue what HRT. I thought
Habitual residence.
replacement
It's the jargon. Habitual residence test.
not
hormone replacement.
Oh, you said UK. This is English.
Yes.
English.
Yes.
And just English now?
Yes.
Welsh?
I thought Social Security.
England, Wales, and Scotland.
Yes,
and
I
there
thought
is
It does extend.
I thought it was a UK.
yes, it's throughout the GB,
GB.
and there's like provision, I think, in Northern Ireland. It's almost always lookalike.
It's not been developed.
It's not a
to Wales.
devolved power for Wales or
No.
Scotland, Social Security. But it's Great Britain, not Northern Ireland.
Well, hang on a minute. Can you just? I'm getting different messages. What's the position?
The disability benefits devolved to Scotland.
Yes. So it's devolved to Scotland, devolved to Northern Ireland, but not to Wales. Is that right?
Not definitely not to Wales.
At the moment.
Again, we'll check that.
Yes.
But I'm just looking at where the residence test is. I don't see it myself in subsection.
I don't see it in subsection 2.
I don't know if this is an different subsection 2.
My lord, in paragraph 14 of our skeleton, the presence test is set out in the Social Security DLA regulation.
That's what I was thinking. That's why I would like the regulations, or we would like the
Yeah.
regulations.
So, Miss Ward, could we possibly have all relevant regulations that we've been just referring to?
If I had a child under 16 and I wanted that child to be sure she got the money, what would I need to have in my folder when I go to the DWP office? You know what I'm getting
Yes,
at?
of course.
Yeah.
Okay.
The regulations were actually made pursuant to the Vires in 71.6, so that's the position. There are regulations.
Yeah.
Now, I think it's just Mr. Berry that's got the right to reply.
I was going to hand up the case of effing, my lord. but it
Okay.
was-
All right. We'll have the case of effing. So just you, Mr. Berry, though. you might well be prompted from your left.
Yes, my lord, yes. And I aim to be done by 1 o'clock.
Thank you.
My lords, my lady, just briefly on the role of the Administrative Commission, because you didn't hear from us yesterday on that, and it was the subject of discussion this morning. There is, of course, the only decision, of course, is to adopt the opinion of the conciliation boards. When we look at, there is no decision to create an interpretive decision one way or the other. So that's what we're confronted with. We don't actually have the answer from the Administrative Commission itself.
And but in terms of what weight it carries in this court,
it carries. It's not binding, as is accepted. Its weight lies in its persuasiveness in my submission. If it's coherent, it's not the clearest exposition of the regulation, and it doesn't provide answers. More importantly, it doesn't, because of the way that the Administrative Commission proceeds when it deals with it. It's voted on by governments, and so when it's adopted by the Administrative Commission, it's not in the nature of judicial reasoning or reasoning. It's all that's done is that the Administrative Commission, politically, if you like, within a particular reconciliation mechanism provided, has adopted.
Do we have the piece of paper or papers
I haven't
that shows the administrative? We haven't got that.
We've asked for it. I haven't ever seen it.
I wasn't aware it had been asked for. I am in the process of searching my files to identify it to be sent.
There must be a piece of paper.
It does exist, and I'm fairly sure I've seen it.
is it just a piece of paper saying we accept it?
It's minutes of a meeting.
Okay.
But literally all it says is this
Adopted.
But it at least gives us the date of adoption.
It gives the date, which I'm fairly sure the court was informed of when the stay was lifted. But
There's no gloss. No.
I had assumed, in fairness to this board, that it was simply we adopt this conciliation board opinion, which just takes us to the opinion which says what it says. In my submission, it's discursive and in large part points out things rather than coming to.
But now we've looked at it even more thoroughly than we did with you. You would rely on that paragraph on one.
We rely on that paragraph in page 155 that we looked at in detail.
And the likewise sentence in particular.
Yes, precisely. Yes, absolutely. But in terms of how one approaches it, anything which is decided on an interstate capacity on which we have not been represented, obviously, because there's no role of the individual applicant to be part of that process, and which is decided by qualified majority voting, which is the procedure specified in Article 71 of the regulation, must be treated with a degree of caution in terms of the task for this court, which has to approach the matter judicially rather than politically.
Yeah, and it's clear from looking at the document in more detail, which we did with Ms Ward, that the submissions were different, particularly.
Yes.
I mean, Ms Ward's submissions followed substantially, developed much more thoroughly by Ms Ward than they were or are recited, but they are in line with what was said.
Yes, unsurprisingly.
To the Commission, unsurprisingly, whereas Belgium did not say the same.
Yes.
Belgian submissions were structured differently from yours, or rather vice versa.
They approach it differently. Each delegation makes submissions to slough off responsibility, and the individual applicant isn't heard in the process. And so you end up with the conciliation board reconciling the opinions which are advanced.
Ironically, Belgium seems to have adopted the personal circumstances of your client.
They haven't been unhelpful in that respect.
Although,
one needs to there is a degree of caution, and of course, a case deciding which state is competent judicially would reach the Court of Justice on a reference from a national court in other contexts, not obviously in this case, but and if there were to be judicial approaches to that question rather than political intergovernmental ones, you would go down that route. Two points in briefly in reply, which we deal with. The Secretary of State's position in respect of the dominance, if you like, of the employment principle, that the place of work ought to prevail. That is something which is maintained under the current regulation. But just to point out that the whole shift from 1408-71 to the current regulation, 883, of 2004 is to take account of the economically inactive being embraced within the procedure. And that doesn't mean that economic activity doesn't continue to play a central role for deciding individual insurance, but it does mean that it's not the only show in town anymore in terms of primary entitlement. Co-terminus with that is that that has implications for when one comes to approach what is a competent state for the purposes of deciding the allocation of responsibility. Because a competent state is not to be decided as if there can be only one. Indeed, even Section 72(7)(b) doesn't approach it on that basis. It simply says, is the United Kingdom competent? But if we were just looking at the European approach, the regulations approach to the issue, it comes in on deciding the purposes of, you work through to it from deciding who is an insured person.
Yes, well, that's the process I went through in a rather ham-fisted way with Miss Ward.
No, it's
America is an insured person. Therefore, the UK is the competent member state.
the UK is the...
So far as the benefits paid to which she's independently entitled.
Yes, indeed. And it isn't to be approached by trying to assimilate into it the different ways in which one can derive concurrent entitlements from other family members. That whole approach is wrong from the off, for the reasons we've canvassed already, and I don't intend to go back to. But it's important that that this idea, which comes out in Judge Jacobs' judgment in paragraph 26 of the Upper Tribunal's judgment, page 51 of the core bundle. He says in the last sentence in paragraph 26 on page 51, the obvious purpose of the article is to ensure that all members of the family can look to one state for their sickness benefits. We say that's just simply wrong. It is not the obvious purpose of Article 21. The purpose of Article 21 is to create entitlements, plural, in the situation where there are family members where one person is moved and other family members may require that, but it doesn't say that therefore they lose their own individual entitlement in their state of residence. The catering for the different ways in which family life evolves when the economically active person migrates is a purpose served by Article 21, but not to displace the analysis for determining what is the single competent state for individual rights of entitlement under Article 11.3e. Otherwise, there would be no job of work for Article 11.3e to do.
Do you accept that even if then there is a prioritisation need or rule or imperative, that it's served in this case by the United Kingdom? So although I know you want to have a choice,
yes,
it's both. As a fallback position, is your fallback position, if there is a need for prioritisation, that is the state of residence? The United Kingdom.
There's an individual entitlement. If one was to, and that is answered exclusively by reference to Article 11.
Let me put it right then. You would like to have two sources, and you can rely on whichever one you wish.
Yes.
Which is the United Kingdom law and Belgian law.
Yeah.
If there has to be a prioritisation,
it's the United Kingdom.
It's the United Kingdom. That's your alternative position,
yes.
is it? Yeah. Okay.
Yeah.
There's choice, but if no choice, it's England or Britain.
Yes. And there's nothing in the individual. There's nothing in Article 21 which would displace our analysis. What the Secretary of State has to contend with, in essence, is that there is within the regulation as a whole, there are a whole series of provisions to cater for reconciliation, to cater for situations where there are priority rules, overlapping benefits, provisions against overlapping benefit entitlements, and provisions for ordering entitlement. And those have to make sense, as well as the general provision in Article 10 for overlapping, and those have to make sense in the context of how Article 11 works. It's clear that Article 11 is confined, and Title 2 generally, works as a self-contained code, not just because the court Justice has said so, but because otherwise the other provisions of the scheme would lack operative effect, and we have to give effect to the regulation as a whole. And that's what I'm reminded of by Mr. Delamere is that the case of effing at paragraph 39, which has illustrates the position with, where there are two workers, shows that there can be two applicable laws. And that the position, and that was under Regulation 1408 of 71, and that now we're in a position where that it's clear that you can have concurrent entitlements generated. And that if we look at, if we just simply look at the language of Article 11, just briefly again for a second. We can see there that the without prejudice clause, it's page 90 of the authorities bundle, tab 11. But just to, I know we've looked at it in detail, that it's guaranteeing benefits under the legislation of one or more member states. And that's critical. It's guaranteeing benefits, notwithstanding the fact, if I can put it, that you have your individual applicable, the legislation for you as an individual applicant is determined by Article 11. It's one or more member states.
That covers the example that's in effing, and it was my Lord Justice Lewis's example of the two parents, one working in France, one working in Belgium, epitomises that.
Yes.
So it's without prejudice to the fact that there are other provisions of this regulation which may guarantee that person benefits under the legislation of France and Belgium in that example.
Yes.
So you have to say, well, what you say that's more naturally, naturally means that you can have more than one benefit rather than that you take the existing benefit away and replace it with one of the other two.
Indeed, and one can see how in the way that lives are led, that it may be that the parent with care in the country of residence has need to go to, in this case, a cash sickness benefit tailored to disability needs arising in the member state of residence, that you have that choice. If you are not exercising it for any reason, or if the employed parent outside the country of the child's residence had a benefit which was available to them, they could apply for it as well, and then we'd be overlapping.
We have to be a bit careful about placing too much store on the English language version of the reg, because we don't know, nobody's actually provided it to us, what the French version or any other versions say.
My lady, that's right.
But because guaranteeing benefits has a particular connotation, but I'm a bit wary about what
the other thing is, because we're interpreting an EU regulation, it's not the normal principle of interpretation. It's having regard to the history and context and purpose and the different language versions. So we shouldn't get hung up, as my lady says, on a particular word. It's what this thing was meant to do in 28 member states, ranging from Poland on the right to Ireland on the left, and all in between, up and down.
Yes, yes.
And it's not just one word there. Your interpretation doesn't just do the
more.
word guaranteeing. It's
yes.
one or more. It's the structure of the
exactly. And if you import anything via the proviso in Article 11.3e, one or more member states, what is it that you're bringing into the definition? It's completely unclear. It's not coherent to draw in through that. One or more member states, and you're forced to look at where you are.
Well, once you've got a multiplicity, which you would have under any language, because you've got the words one or more, then immediately that seems to cut, to me at least, to cut across the idea that you're producing a new state, single, which trumps...
Yes. In fact, it fans out the number of options almost, and it really depends on, as my Lord Justice Lewis says, there are 28 states in question at the material time, and then you're forced to think, well, how am I going to assemble all of this, particularly where lives in maybe two parents, and they may, each one of them have worked in more than one other member state. It reduces this, a scheme that's designed to have a certain simplicity in Article 11. Chaos. That just can't be right. It has, in terms of its operational effectiveness. Yeah, yes, I'm reminded that of course now you might have two insured parents under this scheme, and of course, and which is sort of another way of saying what we were just touching on, and it has and that there's and what do you do then? It's important to confine the definition of insured person and the way it operates to identify the single competent state to the job of work done by Article 1C and also then to Article 11, and not to stray into the issues which we've wrestled with, not just in respect of benefits in cash, but also benefits in kind.
Freedom of movement for work applies to more than one person within a family unit.
Absolutely, absolutely.
Do you want to say anything about how sections G and H of the Upper Tribunal judgment? And Ms Ward made some observations about the fact that the appeal didn't extend to certain aspects of the Upper Tribunal decision.
Well, only this, that our primary submission is that we are within section 72(7)(b). We are there because the United Kingdom is competent, and that the point
because Mira is the insured person, and ergo the UK is competent.
Yes, precisely. And so
does that mean it means is a competent state?
Yes.
Not the competent state.
My lord, yes.
What if there is a prioritisation rule and it is only one state? I know you say it's not, but if it's only one state, it would only be the competent state then if the UK was the one under the priority.
Indeed.
But you say it's capable of being more than one, and because it's capable of being more than one, 72B is capable of accommodating your primary. It could be two states, and therefore it's a competent, not one competent.
My lord has the point.
It doesn't say the competent; it says competent.
It says competent. Yes, precisely. And so the argument which we were, the sort of detour that we went down in the Upper Tribunal on what to do about Article 72(7)(b), and as it's expressed in G and H, what happens in EU law if you're then trying to get round an allocation rule. We don't need. It's not before this court. It's not relevant to.
The only time you lose is if there was one state and that one state was Belgium.
Yes.
Yeah. Okay. Right.
I'm also reminded that the may. Reminded that you can run Article 21 from more than one perspective. You can run it through the father, or you could potentially run it through the child, and that just is one further illustration of why there are concurrent entitlements, and that Article 21 simply can't be, if you like, a footnote to the Article 11 analysis. My lords, I'm conscious of the time, unless
well, thank you very much,
my lady, unless I can assist further.
Well, thank you very much. Well, once again, we're very grateful to all of you for your submissions. It's been extremely interesting for us. I hope it's not been too painful for all of you. It's certainly helped us having this debate in the way that we have. I know it's been vigorous, but it does help us. Thank you very much. I'd also like to express our thanks to those who sit behind you, the juniors, the solicitors, the other professionals working on this case. And I think members of the family are in court. Are members of the family in court or not?
I don't think so today.
They're not. Okay. Well, maybe they're watching on screen. But we're also aware that this is very much underlying. We've talked about law for a day and a half, but this is about an individual, their family members, and we're very conscious of that too, and what they've been going through with all this. So we acknowledge that too. We're going to reserve our judgments. Yes. That means that we will be sending out a draft copy at some point, not too distant future, for council to point out any typographical or other minor factual errors. Not, of course, an opportunity to re-argue the case, however tempted you may be. Please don't do that. Also, can I remind you of the importance of the rubric at the top of the draft judgment. It's not to be disclosed more widely when it's in draft form. There's a great warning about what the consequences of that would be. I would hate any problems like that to arise in this case. Then when we've had your comments back, the judgment will be handed down remotely under the new provisions. We'd be grateful if you would supply us, when you do supply us with your comments, also with the draft order, dealing with the consequences of our decision. If there are any ancillary issues which require to be resolved as a result of our decision, we'll do that, sort that out on paper. So please provide brief written submissions dealing with your competing arguments on those issues. Thank you all very much.
What?